Good evening, everybody. Welcome to Courtroom Insider. I'm Nate Eaton. Surprise, last minute Courtroom Insider here because there is some news in Lori Vallow Daybell's case. She has filed more motions, or at least another motion, and the prosecutor has responded to the motion. We're going to talk about it tonight. We'll do a mini Courtroom Insider so that we can gear up and be ready for the trial. I made it to Arizona just a few hours ago. Thank you all for joining us last night when I did a little live video with Peggy Jepson, our comment moderator, as I was driving through southern Utah. Spent the night in St. George, woke up early this morning, and then made it here to Phoenix this afternoon. And it is hot. It is very, very hot, but nice. Nice to be back. Honestly, feels like I didn't leave. And we are back to cover round 2 of Lori's Arizona case. She does not want Judge Justin Boreski on her trial, which is kind of interesting that she's filed this motion. That's what we're going to talk about tonight, and I want to answer some of your questions, so please put them in the comments below. But Lori has been insistent all along that her trial happen, that she has a speedy trial, and that it gets done. She has demanded that. But now she's asking for a new judge to come into the case, which would postpone her trial. She filed this motion. We got our hands on it today, and let's just jump right into it. Now, you might recall at the hearing last week, well, I guess now 2 weeks ago, at the tail end of that hearing, this is what she said to Judge Boreski.
Your Honor?
Yes.
I would have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right? So
You denied every single one of my motions for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours, okay?
That's the first motion that you've ever granted.
Well,
in my behalf.
File motions that have a legal basis, and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied. Every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?
So he denied the motion. That didn't stop her from filing a paper motion. And here is what it says, or at least part one of it. I'm going to try to zoom in here so hopefully you can see that. It says the defendant, Lori N. Daybell, files this motion and her affidavit is required to show that the Honorable Justin Boreski has a personal bias or prejudice against her. As a result, the defendant cannot receive a fair or impartial hearing or trial before this court. Based on the affidavit, the defendant respectfully moves that the Honorable Justin Boreski proceed no further in this action and that another judge be assigned to hear the case. Now, many of you, I know, have commented that you believe the judge has been overly fair to her, a little too fair, some of you have said, in the fact that he's told her multiple times that he can't give her legal advice, but at some points it does appear that way, that he is kind of helping her along in a way. I have not observed that. I believe that the judge has been fair and he has been out of the spotlight, you could say, not trying to persuade things one way or another. But this is what so she attached an affidavit to her motion. And this is what she says. I, Lori Daybell, being duly sworn, say, Mrs. Daybell has made multiple motions for Judge Justin Boreski to recuse himself from her cases. He has refused. And he willingly violated the Code of Judicial Conduct, Canon 1-2, manifesting bias, prejudice, and cannot be impartial in the defendant's case. On May 14th, the defendant's case are in the worldwide media networks. Okay, let me stop there. I got to reread that. On May 14th, 2025, the defendant's cases are in the worldwide media networks. Justin Boreski refused to recuse himself in direct questioning by the defendant. The judge proceeded to breach his duties of the Codes of Judicial Conduct, Canon 1-2, by further commenting with opinions of the defendant's prior two groups of counsel, the defendant's advisory counsel, and the defendant's motions that he has denied without cause or decision to support his denial of requests. A judge should have recused himself related to the merits of their own ruling. In regard to complaint of judicial misconduct, a judge commits error of laws in the process of reaching discretionary conclusions in abuse of discretion. On the May 14th, 2025, court proceeding, Judge Boreski's behavior and judicial acts fall within the scope of, quote, bad faith. The acts were intentionally committed, and the judge knew or should have known that his actions were beyond a judge's lawful power and without lawful power of judge, but for corrupt purpose, which includes any other than faithful discharge of judicial duty. In Judge Carroll, she quotes case law, the motions that she quotes another case, I should say. The motions that the defendant's prior to legal counsel teams, the defendant and her current advisory counsel have advised for the defendant to file for evidence and further motions of requests are crucial to the defense preparation. Witnesses, experts, evidence, proof of innocence, cross-examination, rebuttals, and foundation to the defense, all of which Judge Boreski has deprived the defendant of access to the evidence. A judge abuses his discretion in controlling discovery. Judge Boreski crossed the line of neutrality when he misemployed his powers, when he assumed role using his judicial powers to advantage or disadvantage a party unfairly, thus giving the impression that this court has opinion. Improper judicial intervention results in prejudice. The, quote, facial expressions, attitude, demeanor, and statement deprive the defendant of a fair and impartial hearing violation in conduct that is prejudicial to the administration of justice. A request for presiding disciplinary judge is being made on Judge Justin Boreski. A request for presiding disciplinary judge is being made on Judge Justin Boreski. I'm not sure what that means. On May 14th, Judge Boreski refused to apply or understand the direct guidelines of the Maricopa County Sheriff's Office own attorney, Maricopa County Attorney's Office Civil Attorney Joseph Vigil. On May 20th, 2025, Maricopa County Sheriff's Office response to removing restraints during trial on page 3, quote, without any restraints in the courtroom, Madison County Sheriff's Office would recommend an unarmed detention officer and an armed sheriff deputy in the courtroom. This goes back to the fact that Lori has said she doesn't want to wear the belt, the rack belt, and she wants to just have an extra deputy with her. The sheriff's office gave some recommendation to the judges to keep the courtroom secure, to make sure Lori Vallow Daybell doesn't take off. The judge issued his ruling and said, I mean, you can give recommendations all day long to a judge. They're going to rule how they're going to rule. I was just watching Judge Judy a minute ago. She's going to rule how she's going to rule. So while the sheriff's office might say this or that, the judge is going to say, no, this is how it's going to be. Lori's upset by that. About the belt is visible on the defendant and has fallen off the defendant in prior trial proceedings. The motion was denied by Judge Boreski. Apparently, at one moment, the strap of the belt in the last trial came down so the jury could see it. I don't know about the belt falling off the defendant in prior trial proceedings. I never saw the belt fall off the defendant, but perhaps it did. Anyway, she goes on to talk about affirmative acts or omissions performed by the judge. Judge Boreski's denial of the sheriff's office motion or recommendation, she says. violated and was done on bad faith. And then she goes on to talk about the speedy clock. As a defendant, you have X amount of days to have your trial. She has not waived her right to a speedy trial, much like Chad did in Idaho, and that's why his trial was able to be held later. Lori has not. So she's saying that the speedy trial clock has exceeded the maximum days. She brought this up. She's brought this up a few times, and the judge told her before that we were supposed to be in trial, the other trial right now. That trial was supposed to wrap up just last week, I believe, or this week. And then he said, you can't have two trials at the same time. You could ask the state to combine them, and the state actually kind of seemed open to that for a moment, but Lori didn't want that. So she's now saying that the judge, another reason he should be DQ'd, disqualified, is because, quote, the speedy trial has exceeded the maximum days. The act is violated, thus the case should be dismissed. Okay, so now she's going into the case should be dismissed. Dismissal without prejudice is not a toothless sanction for a speedy trial action violation. No continuance periods may be excluded from treaty trial computation. A continuance period is not excluded from the speedy trial calculations. On Judge 9th, 2025, Judge Boreski in trial, which media networks aired his comment against the defendant. Okay, so now she's going into another area. She's talking about the judge should be disqualified. I don't know if she listed any clear and concise reasons in the beginning, but then she went on to talk about how her trial wasn't given in a speedy amount of time. So that's another reason he should be disqualified. Now she's saying he should be disqualified because of a comment he made in the last trial when the prosecution objected to a line of questioning about faith and Nephi, I believe. Judge Boreski said, quote, I guess to the extent you're comparing yourself to those biblical figures, I will allow it. The statement in the statement to whatever the questioning she was doing with the witness. She goes on to write, Lori goes on to write, this was a malicious act by Judge Boreski to the defendant manifesting discrimination and religious persecution against Mrs. Daybell's religious exercise, belief, and practices. The comments compound the prejudice of an erroneous misunderstanding for the purpose of fundamental error. The defendant only needs to establish one prong to prove fundamental error. A judge who engages in improper behavior while on the bench is sanctioned, imposed, quote, unprofessional conduct, and violates a court rule. Under this, another rule, disqualification, one grounds a judge must recuse himself for any proceeding while a judge expressed an opinion concerning merits, and on and on and on. The comment is order for dismissal. She says, I am the defendant in the above entitled case. I am informed and believed, and based on information and belief, allege that the Honorable Justin Boreski, the judge before whom this case is pending, has personal bias against defendant Lori Daybell in favor of the state. A judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Facial expressions, attitude, demeanor, and statements deprive the defendant of a fair and impartial hearing, bias, or prejudice of judge. A judge shall not preside once affidavit is filed. The facts and the reasons for this belief that such bias or prejudice exists are statement of facts above. Signed, Lori Daybell. Okay, what's going to happen from here? The judge is going to hear this or rule on it. And he could say, okay, I'll advance this up. I've spoken with a few attorneys today who say that there is, this is based on faulty logic, that really there's not much here. The judge could say, I received your affidavit, I received your motion, I'm going to deny it. If he really felt that she had a point or something, it could move up to another judge, and he could release the case. But again, if that happens, we're not going to trial on Monday. And I don't know if the judge is going to do that. This is going to be interesting because Lori obviously has some strong personal feelings against Judge Boreski. And now that the trial, if she goes into this trial passionate about it, heated about it, you could see some interesting fireworks perhaps as the trial goes on. And I think the judge will take whatever comes with this. Now, the state has filed a response, and I just got it. I got into Arizona. I sent an email. I said, can you send it to me? I paid my $16 and I got the documents. They charge per page. That's why it was $16. So let me make this big here and you can read it with me. And this is how Trina Kay is responding to Lori's request. The state of Arizona, through undersigned counsel, responds to the defendant's motion to disqualify Judge Boreski. Defendant's motion should be denied since established any judicial bias, appearance of bias, or fundamental error. A defendant's motion to disqualify the judge heavily relies upon the fact that Judge Boreski has provided legal reasons to deny many of the defendant's motions. He sustained objections made during the trial, and he found no prejudice to the defendant when he excluded 18 days and scheduled this trial to begin on June 30th, 2025. So there's her kind of synopsis as to why it should be denied. The defendant previously incorporated her allegations of judicial bias in her motion for new trial. She also made oral argument to disqualify the judge. The judge issued a minute entry providing his reasoning for denying a new trial based upon the defendant's allegation of impartiality. On May 14th, the court put on the record his reasons for denying the defendant's motion for the judge to excuse himself. The court put on the record that he had no personal bias toward the defendant, that he has accommodated her requests, that he has allowed her additional time beyond that allowed in the rules to obtain expert testimony, and that denying her motions when they had no legal basis of not evidence of bias. And then they go on to quote some case law saying that, why the judge does not have to disqualify himself. Defendant's arguments in support of judicial bias are similar to the allegations made by the defendant in another case. Defendant's motion to disqualify the judge should be denied since the defendant has not established any judicial bias, appearance of bias, or fundamental error. Now, Lori Vallow Daybell filed one other motion. Well, I guess I should say response to a motion from the state regarding one of the witnesses, Tammy Latchchick, who worked for the police department. The state had filed a motion to preclude inadmissible evidence relating to her, basically saying that some personnel matters, personal issues concerning her should not be admitted into the case. Lori Daybell responded to it by saying that her mental state, credibility, inaccurate probabilities, and probative value would be outweighed by unfair prejudice, and saying she was a forensic technician for the police department. And then Lori goes on to give a very lengthy response that I'm not going to go over tonight, but she sounds like she does not want this witness to take the stand, that this witness may have had some issues with alcohol, according to Lori Vallow, and what is on this motion, and some other. Lori Vallow Daybell accuses her, the Miss Latchchick, of providing false information, misleading statements, misrepresenting the facts, lying on the job, all sorts of stuff. I'm not going to dive too deep into that one tonight. I need to study it further before I go on and talk about it. But she basically, I think there will be some sort of, I don't know if the judge is going to take this and say, yeah, Lori, you're right, we're going to let it all in, or if the judge is going to say, you have to be very specific, and when this witness is on the stand, stick to the facts of this case. However, whatever DNA she collected at the scene, whatever forensic stuff she got, you have to stick to that. And that is what the judge could say. And Lori might want to go beyond the scope with that. She might want to go, as wide as she can to try to ask this witness questions. We'll have to see. I apologize. I don't sound more up to date on this. I literally just got these documents as we've been sitting here talking. So I can review all that and we can touch base on that more as we go. So those are the motions that have been filed. Now let's talk about what happens next. Tomorrow at 1:00, court will be in session, and it should be, I imagine, a relatively short hearing. It will not be live streamed. There won't be any cameras there. This is where the judge and the prosecutor and the defense go through the jurors who have sent in their e-questionnaires, and they determine which ones they don't want in and which ones they do want in, and they kind of go down the list. And I think last time they did this for the last trial, it took like an hour. It was quite short. I will be posting live updates though on eastidahonews.com and on my X feed, so you can follow me there if you want to read the live updates from the courtroom. Then on Friday morning at, I believe, 10 or 10:30, one of those times, we will be back in the courtroom with more jurors, with the actual jurors who come to court, and then the jury will be picked. And again, that could just take a short amount of time as well. Last trial, it was fairly short. So we could see what happens with that. Once the jury is picked, there'll be 12 jurors, 4 alternates. Then the judge will likely swear them in and, make sure that they're ready to go for Monday morning when the trial begins at 10:30. Here we are, 10:30, Monday morning, the trial starts. And so tomorrow night, we'll be back for a Courtroom Insider. And then also again on Friday night, and then Sunday night we'll kind of do a recap of what this case is all about for those of you that are just tuning in for the first time and wondering what we're talking about. I am so excited. We have a new sponsor for Courtroom Insider for this trial, newspapers.com. I have to tell you about this. Was it last year? I was at CrimeCon with Erica, my wife. I think it was in Nashville, I believe. So 2 years ago. And I was walking through, and the ladies and the guys at newspapers.com stopped us, and they said they're big fans of Courtroom Insider. They watch. And they offered my wife and I a subscription to try it out. And if you love history, if you love news, which I do, if you love crime news, which I know you do, it's a fascinating website where you can find stuff about crime, about history. So we met them at CrimeCon. They gave us some shirts, which I brought here. I'm not wearing it today, but maybe I will in a couple days. And then we saw them again at Roots Tech in Salt Lake City. They had a booth there. And a couple of weeks ago, they sent our entire staff at East Idaho News brand new t-shirts. That they're really comfortable shirts. So happy to say that newspapers.com is sponsoring Courtroom Insider for this trial, for the Brandon Boudreaux trial. And that what does that mean? It means that I can be here in Arizona covering it every day to bring it to you every night. So big thanks to newspapers.com for helping us out here. I do want to get to some of your questions. Here we go from Peggy. She gathered these from our audience. I heard Lori is getting Amazon and other packages from her fans. Is this really allowed? Does she have food delivered to her cell? No. From what I understand, the only things that are allowed in are letters, and I had to check. I had a email about that I asked about. But no, she cannot get Amazon package. She cannot get food. She can get food from the commissary. So that costs money, and I believe the commissary comes about once a week. In most facilities, it's once a week, and you can order like Pringles or Doritos or Soda Pop or something like that. So she cannot get that. She can get, oh, darn it. I'm sorry. I had it ready. I might have to look and get back to you about the what she can and can't get, because it's very limited. You can't like DoorDash food to the jail, because if that was the case, every single night there would be a massive line of cars outside the jail or the prison with people dropping off McDonald's. And you can't. The only thing you can send from Amazon to the jail is paper-bound books. That's right. You can send books that are paper-bound. So there we go. How is Lori paying for her case? How did Chad pay for his, and how did she pay for her case in Idaho? She didn't. You and I did. The public did. In the beginning, she didn't, and she's not paying for it here. It's taxpayers that are paying for it. She has a public defender. Well, she kind of has a public defense team, even though she's the main attorney, and that's how she's paying for it. She doesn't have to pay for any of it. Chad did hire a private attorney, John Pryor, and he likely paid for it with Tammy Daybell's life insurance policy. And that's why he had a private attorney, and he only needed the one attorney, John Pryor, to defend him. Whereas Lori, because it was a death penalty case, she needed two attorneys, one who was death penalty qualified, and actually John Thomas is actually death penalty qualified too. So we're paying for it, the taxpayers. Why isn't Chad being charged in Brandon's case as a co-conspirator? There was footage of them in the storage unit together. Is it too late to bring charges on Chad? I don't think it's too late. I do know that the prosecutor in Maricopa County has said that they don't feel that there's enough evidence to get a conviction on him. And maybe if something changed, or maybe if suddenly Lori gets a conviction on the case here, they would, but I don't foresee it. He's on death row in Idaho. He's going to be there forever. So I don't know if they'll charge him here. I don't suspect it. Where do they think Tylee Ryan was killed? I think the opinions on that are differing. In fact, how she died too is the big question. Some people believe that she was killed right there at Chad's property. Some people believe she was killed somewhere else and just brought to Chad's property. The amount of time that Alex was there the morning when he disposed of Tylee's remains was quite short. I don't to actually kill a body and burn it and whatnot. But there's, I think the one of the main lines of thoughts is that she was killed somewhere else and then brought to Chad's property. But I don't think we will ever know where she was killed unless Chad or Lori decides to say something and the police can go to that location and actually find evidence. Or yeah, it's just sad. I don't know where she was killed. How is Lori getting her hair and makeup done? This does not seem fair. Well, you can order makeup from commissary, a limited amount, and Lori is a hairstylist, and she can use, from what I understand, you can get like the t-shirts they get in the jail, you can get them wet and curl them and do your own curls, and that's likely how she's doing it. She's not having a team come in to give it to her. Dateline did not give her hair and makeup, from what I've been told. She just is kind of doing that on her own. Will Lori have to wear a stun belt again? Yes, she will. We kind of talked about that, and she will be wearing that belt again. Okay, I think that's it. If you have questions, please leave them in the comments. We'll try to get to them tomorrow. Here's where you can find me all along. I'm on Facebook, Instagram, Twitter, X, and YouTube, East Idaho News, and also Meetin' the Eatons. It's fun to post a couple of family updates over there. We'll be back tomorrow again, tomorrow night, 8 o'clock Mountain Time, 7 o'clock Arizona time, from this very spot, breaking down the Courtroom Insider, whatever happens in court with the Lori Vallow Daybell case. Appreciate you watching wherever you're at, and we'll see you tomorrow.